a faculty member here. I'm moderating this panel. We have a really interesting set of papers, presentations here for this panel today. You have the if any of you have the agenda for today's symposium, you can just look at the bios of our amazing speakers, so that we can save on some time to go away with the more detailed introduction. But we'll have in order of speaking, we'll have Joanne first, Cheryl and Kansha, and then finally Jennifer, and then they'll be speaking for about 15 minutes each, and then we'll open it up for discussion and question and answer. Okay, Joanne, great.
Okay, good morning, everyone. Can you hear me okay? So it's a pleasure to be with you. I'm in town from Edmonton. You'd be surprised to hear that we had really balmy spring-like weather. So the snowstorm yesterday caught me off guard, but that's winter in Canada for you. So my name is Joanne Cave. I'm a practicing lawyer in labor, employment, human rights, constitutional law, and public policy research and analysis. And I first want to acknowledge the significant research contributions of my student research associate, Austin Lees, who's been supporting me with this research project. So the constitutional features of Canada's medical assistance in dying regime has always been a subject of personal interest for me. I grew up in rural Alberta, and one of my earliest memories of this subject was driving around in my dad's pickup truck in the early 1990s as he collected signatures for a House of Commons petition for Robert Latimer in our small farming community. Like many Canadians, my dad was very engaged in public debates about euthanasia in the 1990s, and I'll speak about some of that evolution today. So in my presentation today, we will discuss some of the unsuccessful attempts to legislate the medical assistance in dying regime as part of the historical legacy of charter. Our research project puts constitutional and legal history in conversation with social policy theory to better understand what charter litigators can learn from Carter as an unlikely positive rights case study. I think this is a nice paper to kick off the panel. I'll be speaking about some of the history and evolution, which is always helpful to kind of refresh our collective memories, taking a look at how Carter came to be before exploring how Canada's medical assistance in dying regime will evolve in the future with the other panelists. As some initial framing for the paper, part of my work now, I do some advising with nonprofit organizations on their advocacy efforts. And so many advocacy organizations are engaged in strategic litigation opportunities when they arise, but we know that happens very infrequently. But often their primary focus is advocating for policy change through lobbying or public awareness campaigns. So this research project focuses on the intersection between charter litigation and policy advocacy efforts to better understand the complex and winding path to social change that led us to Carter. So I wanted to start with this quote. So this is from Carter, paragraph 44. Stare decisis is not a straitjacket that condemns the law to stasis. Trial courts may reconsider settled rulings of higher courts in two situations: where a new legal issue is raised and where there is a change in the circumstances or evidence that fundamentally shifts the parameters of the debate. So as we know, Carter is frequently referenced as an important case because it talks about departures from stare decisis. The Supreme Court indicated in sort of cryptic language, I think, that when circumstances or evidence fundamentally shifts the parameters of the debate, but I think it's an interesting conversation to be had about what that means and what exactly shifted between 1993 when Rodriguez was rendered by the Supreme Court and subsequently in 2015 when Carter was rendered. So part of the discussion I'll be having today is about what lessons charter litigators can sort of extract from that period of time, particularly because there were some interesting developments in legislative policy and public opinion. So a little bit of context for you. I think as charter scholars or litigators, we often focus on the legal side of this debate and how Carter came to be, but there were some really interesting legislative attempts to develop a medical assistance in dying regime from Parliament. So there was at least 10 by my count. I suspect there might be others as well. They were all unsuccessful. So they were attempts in both the House of Commons and the Senate from the early 1990s until about 2014. These were private members' bills initiated by Liberal, Conservative, and New Democratic members of Parliament at different periods of time. Different governments, as well as senators, also brought this legislation forward. These efforts failed for numerous reasons, some more procedural in nature, so the legislative session ended before they could take it to a vote. In other cases, the votes were unsuccessful, and you can appreciate the number of concerns that parliamentarians raised. Some were moral, ethical concerns, uncertainty about appropriate eligibility criteria, safeguards, and coercion. So since Carter was rendered by the Supreme Court in 2015, as we all know, Parliament has engaged in a lot of legislative reform efforts to further refine the regime. And as of November 2025, the federal government estimates that more than 75,000 Canadians have access to medical assistance in dying. Just a bit of a timeline for you. This is not exhaustive by any means, but I think it illustrates some of the developments that occurred in that time period. 1982, Dying with Dignity Canada, one of the most important advocacy organizations of many in the conversation. They were first incorporated as a registered charity at this time. They weren't at this time engaged directly in sort of euthanasia, assisted suicide advocacy, but they were doing some other advocacy work around issues like advanced directives. As I mentioned, between 1991 and 2014, many attempts to legislate a regime. 1993, as we know, Ms. Rodriguez was unsuccessful with her appeal before the Supreme Court. The day that the decision was rendered by the court, she appeared in a news conference and implored Parliament to reconsider the issue and to implement a legislative regime. Following Rodriguez, we had a series of, I think this underground euthanasia sort of community existed all along, but I think there was a resurgence or a bubbling up of cases where physicians and right to die activists were assisting individuals in ending their own lives. One of them was Dr. Cheryl here in Toronto, who is assisting a few HIV positive patients in obtaining lethal means to end their lives. And so this kind of demonstrated at that time some discomfort and challenges that criminal courts had with prosecuting these types of crimes. One event that's not reflected on the timeline in 2011 was also a really important year. That was the year that the Royal Society of Canada expert panel issued a report called End of Life Decision Making, and that recommended the legal medical assistance in dying regime. Like with many social policy issues, Quebec is always, I think, one step ahead of the rest of Canada. And so in 2014, Quebec introduced their own provincial medical assistance in dying regime through provincial legislation. There was an agreement for federal prosecutors that they wouldn't prosecute efforts to assist individuals in Quebec at that time. And obviously that shortly predated the legalization of the full Canada regime for medical assistance in dying following Carter. I think it's always helpful to, as lawyers, we really focus on the legal principles that we can extract from judicial decisions, but it's always helpful to reframe in the individual plaintiffs who brought these decisions forward. So just a few images of Ms. Rodriguez. She was very much assisted by an NDP member of Parliament. He was assisting her with appearing at news conferences. She also appeared at a House of Commons standing committee while she was still well enough to do so. He was present when she ended her life. And Gloria Taylor, one of the lead plaintiffs in Carter, was also a very active advocate and was very engaged in public conversation as well. The history, the legacy of Rodriguez and Carter is also one of really strong engagement with Canadians, very active protest, different kind of perspectives and positions on what a legal medical assistance in dying regime should look like, if at all. So these images sort of characterize sort of some post-Carter responses, but there was some really vigorous engagement in the 1990s. Robert Latimer is one example of an individual who really galvanized public conversation and debate, both in Canada and internationally. And just an image of an unsuccessful vote. This was Bill C 314. In an uncharacteristic post-judicial interview with the Globe and Mail, which judges certainly don't do very often, commenting on decisions they were part of, Justice Jack Major, who is one of the presiding justices in Rodriguez, he spoke in 2011 about his disappointment that Parliament hadn't followed or taken heed from the Supreme Court decision to implement a legal regime that they felt implemented the appropriate safeguards. I thought this quote was kind of interesting. I think it reflects a bit of unconventionally dialogue theory in action. Obviously, courts are limited in the extent to which they can or should provide direction to the legislative branch of government, but it's a rare window into the mind of a member of the judiciary about what they had hoped would happen following a Supreme Court decision. So this is where we bring together some legal history, some constitutional theory, and the world of policy studies, which we don't often kind of put together in the same conversation, but that's one of the key objectives of our paper. This is a visual representation of John Kingdon's multiple streams theory in policy studies, which suggests that public policy issues surface or converge at particular moments in time. Specifically, these three streams, so problems, policies, and politics, converge at the same time, and this opens a policy window. There's a similar theoretical framework in sociology. It's the theory of critical junctures in historical institutionalism. I won't expand too much further, but I think they parallel nicely. Critical junctures, that theory proposes that there's brief periods of flex or opportunity that emerges after long periods of social stability or equilibrium. So in my view, these theoretical frameworks, I think, are a useful complement to when we talk about dialogue theory. So the well-established constitutional law theory that courts and legislatures engage in ongoing dialogue after a law is struck down as being unconstitutional. And in my view, the theory of policy windows helps to explain how, when, and why social policy issues surface in the public domain and first become on the foreground of charter litigation in the first place. So just a few key takeaways from the paper. The first, and I think you can appreciate this from the historical comments that I've made, that social change is incremental. Rodriguez kind of laid the foreground and really brought these issues to the fore. If you go back and you look at clips from CBC or other media outlets at that time, it really generated a strong public response, and I think that laid the groundwork for further legislative reform efforts and general kind of public discourse about the issue. The importance of narrative and storytelling. I think this is a really understated part of charter litigation, that the public really accesses constitutional law and charter litigation through individual narratives of Canadians who are experiencing challenges accessing services. And that really played out in both Rodriguez and Carter, where their narratives, the plaintiffs, them appearing in news conferences speaking about the decision, really continue to evoke that public response. Policy windows create opportunities for dialogue between courts and legislatures. I don't mean to suggest that that the way that Carter came about was overly simplistic. I think there's a lot of comments you can make about the changing composition of the court, the evolution of charter jurisprudence. There's lots of factors there. But I do think there was an interesting policy window that was created that particularly laid an evidentiary groundwork for Carter to be a departure from the stare decisis that was Rodriguez. And then the last point here, the key role of advocacy organizations in shaping public discourse. So as we know, interveners have a long and storied history of active engagement in charter litigation at the Supreme Court level. If you take a look at sort of the intervener engagement in Carter, I think it really shows that a lot of those advocacy organizations coming from all different perspectives really shored up for that decision. I think they really felt compelled to add different and unique perspectives to that debate. And say what you will about whether interveners really have a meaningful bearing on the outcome of Supreme Court decisions, but I think it does demonstrate that advocacy organizations do have a critical role to play. In Carter, the lead plaintiff was very much supported by the BC Civil Liberties Association. That was a key way that the litigation moved forward. And then just from a practical perspective, I think there's some interesting comments to be made about, I don't have insight. I certainly wasn't one of the council involved in either Rodriguez or Carter, but as an outside observer, I think there's some interesting observations to be made. The first is for charter litigators to take stock of the policy and legal landscape, and I think this is really intended to inform whether there's a sufficient evidentiary foundation to be able to make some of those arguments that would support charter analysis. The second one, marshalling social science evidence effectively. For charter litigators, I think the last place they want to be is having procedural debates about the admissibility of their expert evidence. The more groundwork charter litigators can do to ensure that the evidentiary foundation of what they're arguing is really robust and well developed. And you'll see this if you ever take a look at the trial decision of Carter. The voluminous evidence, expert evidence that they had to work with really, I think, set the foundation for really productive conversations subsequently at the appellate level. And it also avoids that tension of interveners or other parties at appellate levels trying to introduce new evidence. If there really is a robust evidentiary basis at the beginning of the litigation, it really supports more, I think, comprehensive decision making. The next one, ripeness and justiciability. These weren't live issues in Carter, but I think we've seen it more recently in some constitutional litigation here in Canada. Ripeness came up in brief ways in the recent UR Pride work. Justiciability, we've seen that around affordable housing, charter litigation, and otherwise climate change. I think it, in some cases, gives courts an easy opportunity to sidestep or divert from some of these morally challenging questions like medical assistance in dying. So I think for charter litigators, it's important to give thought to those issues and how those types of arguments might be effectively responded to. You can appreciate that there weren't necessarily issues here in Carter or Rodriguez as well, because the factual framework was well developed. It wasn't questioned that the lead plaintiffs were seeking medical assistance in dying for their own purposes, given their own medical condition, which had developed to a point that they were seeking that. But I think generally in constitutional litigation, these two issues come up more frequently than we might expect. Engaging interveners strategically. So really thinking through in charter litigation how to align intervener perspectives to bolster and deepen the arguments of the lead parties. I think there's always a live debate at the Supreme Court about interveners trying to add or supplement or divert from the core issues or trying to add new evidence. But if there's really strategic and thoughtful use about how interveners can bolster, deepen, add new perspectives, I think that is a helpful frame when thinking about these issues in the future. And then the last one, I think I'm speaking to the choir here, but I do think there is an important role for lawyers, especially lawyers who are interested in charter litigation issues, to think more broadly about the types of contributions they can make. So charter litigation comes up once in a blue moon, and the facts have to be right for it to move forward, and there has to be resources in place to move it forward. But I think if there's one of the takeaways I'd like for you to reflect upon from my presentation is there was a very extensive history of House of Commons standing committees on medical assistance in dying, numerous legislative reform efforts. Those are still ongoing, very vigorous and active discussions. And I think lawyers have a lot to contribute to those discussions about law reform and supporting advocacy organizations with being strategic in how they approach those questions. So I'll leave it there. I think I'm probably at time. Really looking forward to the discussion. Thank you very much.
Okay, thank you so much, Joanne. We'll have Trudeau and Kangshan. So you want to come from here?
Yes. So
Okay. Is it on?
and
Sorry.
Oh, the clicker.
hello. So thank you so much. It's an absolute pleasure to be here. My name is Kansha. I'm a research associate and the coordinator for an interdisciplinary project, which is being funded by SHIRK. And we're exploring the impact of COVID on elder care and disability rights. And Trudeau here has done extensive work on need, which is an understatement. Please stress that. And what we saw are very striking connections between elder care and maid. And this is what we're exploring in our paper today. So I want to start with a real story. Sorry, I will multitask here. Did that work? I want to start with a real story. In April 2023, a 79-year-old woman was locked out of a long-term care facility, and she later died of exposure. And the subsequent investigations, the regulator held that the home had failed in providing care and to protect her safety. So why are we beginning here? Because this tragedy isn't just about one home, but it reflects a deeper reality. When elder care systems fail through neglect, inadequate staffing, policies that prioritize efficiency over dignity, the consequences can be fatal. And here's the question that frames our discussion today. If our health system robustly facilitates MAID while leaving supports for living fragile, are we creating conditions that push people towards ending their lives, not because they truly want to die, but because living with dignity feels impossible? Is that the real choice under Section 7? And I hand this over to Trudeau.
Yes, our case study, basically in the paper, we discussed this in more detail, fits well with the discussion that we saw this morning, particularly about omission and commission and the differences in the approaches that we see. So our case study is a story of how an incoherent approach to positive and negative rights, or the failure of robust recognition of positive rights, can have hugely problematic consequences when combined. It's a case study also of prioritization of what we see as a narrow liberal concept of individual rights, and a failure to look at rights in a broader socioeconomic context. So court interventions and I speak here about several, not just Carter, but also the lower court decision in Trichon, which led to the change in the MAID law. So court interventions under a negative rights approach to the Charter resulted in a remarkable prioritization of state-funded medical system implemented system of MAID in an area of practice where the Supreme Court clearly recognized that competing interests intersect. MAID cases and law reflect the idea that autonomy under Section 7 requires more than non-interference when it comes to supporting ending of life in particular circumstances. But so far, courts have appeared hesitant when it comes to providing necessary supports for living, or recognizing the necessary supports for living and robust protection of life. So I won't say so much more about some of the issues around MAID, because these were already touched upon, about the number of people that receive MAID. But in our paper, we discussed particularly some of the problems, because that's what we try to portray in our paper, is a contrast between, in our view, easy access to MAID versus problems with access to adequate care. And so if you kind of look at the Health Canada reports that have come out in relation to MAID, we cite that as one of the reasons why we should be concerned. If you look at the reasons why people say that they suffer intolerably, you see that a significant proportion, and we're talking about 50% people refer to loss of independence, isolation, dependence on others as an experience of intolerable suffering. Health-related reasons often are only remotely connected to the reasons why people ask for medical assistance in dying. And there's also evidence that we discuss in the paper, and that I've been involved with also as a member of a Ontario Chief Coroner's Committee on Medical Assistance in Dying, where there is evidence that we see that voluntariness and equity concerns are raised by some forms of MAID, and a broad and flexible practice of MAID. So international experts have warned that enabling MAID without addressing systemic inequities risks institutional ableism. And I think in what we try to show in our paper is that this has to some extent been reflected in the current practice. These concerns have been downplayed by federal and provincial governments and parliamentarians, and by core providers who often disproportionately influenced MAID policy making and are currently pushing for further expansion. So I'll simply cite here two documents or two statements by international human rights experts that show the kind of the clash between what has been embraced as a kind of a charter right and what international human rights experts warn about. So 2000 21 letter by the Special Rapporteur on the Rights of Persons with Disabilities, Special Rapporteur on Extreme Poverty and Human Rights, and the Independent Expert on the Enjoyment of All Human Rights by Older Persons. They wrote a letter to the Canadian government during the parliamentary debate about Bill C7, which led to the expansion of MAID, expressing grave concern about the expansion outside of the end-of-life context, firmly stating that disability, and I quote, disability is not a reason to endorse medical assistance in dying. But they also warned that MAID closer to the end of life for elderly persons can be problematic. And you have there a quote from that letter. Especially older persons with disabilities may feel suddenly pressured to end their lives prematurely due to attitudinal barriers, as well as the lack of appropriate services and support. And then I'll simply mention, and I'll hand it over to Kangsha to move to the elder care issue again. The Committee on the Rights of Persons with Disabilities commented as recently as 2025 on Canada's report on its accomplishments under the CRDP, and it refers there to the idea of the concept of choice. The concept of choice creates a false dichotomy, setting up the premise that it is valid to enable disabled persons' death without providing safeguards that guarantee the provision of support, and on the basis of ableist assumptions that de-emphasize the myriad of support options that could allow persons with disabilities to live dignified lives. So you see here with this reference to the architecture of choice, the importance of choice in context in the international human rights community, the kind of arguments that we make in the context of elder care.
Thank you. So you may remember during COVID, there was heavy emphasis on social distancing. And where long-term care homes were concerned, family access for a certain period of time was completely stopped. Now, post-COVID inquiries found something vital. Family caregivers were not just visitors. They're essential partners in care. They provide hands-on support like feeding, bathing, and mobility assistance, and they advocate for residents' needs. When pandemic restrictions excluded families, residents experienced severe physical decline, cognitive deterioration, and depression. Isolation accelerated dementia symptoms, and some showed signs similar to confinement syndrome. These harms were compounded by staffing shortages. Without family involvement, critical decisions were delayed, especially for residents with cognitive impairments. So policies that restrict family access replicate the same harms as one that were seen during COVID. Ontario's More Beds, Better Care Act was introduced in 2022 to ease hospitals' bed shortages. It lets hospitals label patients as needing alternative level of care, meaning they no longer require acute treatment, to require their transfer to long-term care homes, of not necessarily the choosing of the patient, but rather the hospital can decide which long-term care home they must go to. And refusal comes with a $400 per day penalty. So advocates challenged the law under the charter, arguing that it violated Section 7 rights. But in January 2025, the Ontario Superior Court upheld it, calling the harms modest and the penalty a modest economic consequence. Justice Center referred to the fact that it only constituted 1/3 of the real cost, reasoning that freeing hospital beds outweighed individual harms. The reality is, the impact is harsh when distance, disability, and poverty intersect. In Northern Ontario, placements can be 150 kilometers away, raising travel costs, reducing family visits, and weakening support networks. Low-income families often can't afford transportation. Relatives with disabilities face barriers that make long trips nearly impossible. The result? Isolation, helplessness, and a sharp decline in quality of life. Virtual visits can't replace hands-on care or emotional presence. International law provides important anchors for this discussion. The Vienna and the Madrid plans emphasize family involvement and integrated social supports as central to elder care. The UN principles for older persons articulate rights to independence, participation, care, and dignity. Canadian courts apply a presumption of conformity with international law, using these instruments to inform a purposive reading of charter rights. This doesn't create new positive obligations, but it shapes how we assess arbitrariness, overbreadth, and gross disproportionality under Section 7. When legislation prioritizes systemic efficiency over autonomy, like the Better Care Act, it conflicts with these global norms. Aligning domestic policy with international standards means recognizing that the right to health includes freedoms and entitlements. So to conclude, we return to the central question. How do we reconcile robust facilitation of death with fragile supports for life under the Charter? First, Section 7 requires us to scrutinize laws and policies that skew decisions towards irreversible life-ending options. Second, we face a structural imbalance. MAID is well supported and streamlined, while elder care remains fragmented and underfunded. This undermines meaningful choice. And third, what does a rights-based elder care framework look like? So A, expand capacity for high-quality long-term care so older adults have real options. B, integrate family involvement as an essential part of care and respect placement preferences to maintain proximity to support networks. C, take seriously the obligation of the state to protect the right to life, including through reevaluation of MAID expansion and the development of robust control of MAID practice. And D, prioritize timely access to palliative care and community-based services so MAID truly becomes a last option, not a default when support fails. These reforms align with international human rights norms and respond to evidence on the harms of isolation and systemic neglect. So we conclude, autonomy must mean real choice and not coerced by neglect or isolation. Thank you.
Okay, so much question, Asper?
Hi everyone, I'm very excited to be here today. Thank you to the Asper Center for having me. Before getting into my paper, just a quick comment that I work at the Community Legal Assistance Society, where I represent people with mental disorders. But the views that are expressed in my paper and at the conference today are my own and don't necessarily reflect the organization I work for. My paper that I'm presenting today is based on my master's thesis research, which was supervised by my co-panelist Trudeau Lemons. So I'm very thankful to him for his guidance in my research. And what I'm going to talk about today is the issues that arise when the systems of medical assistance in dying, or MAID, and involuntary psychiatric treatment and detention intersect. So in Gosselin, as has been discussed today, the Supreme Court of Canada recognized that in special circumstances, Section 7 of the Charter could ground positive obligations to sustain the right to life. And this potential has been affirmed by appellate courts more recently in cases like La Rose in Canada and ACNJF in Alberta. But while that potential was recognized, it has yet to be actually applied. So in my paper, I argue that making MAID available to involuntary psychiatric detainees without additional safeguards creates just the kind of special circumstances that the Supreme Court was alluding to in Gosselin. I argue that, firstly, the legislation as it currently stands violates involuntary psychiatric patients' Section 7 Charter right to life. And secondly, that the government has positive obligations to sustain this right by creating safeguards to ensure that the conditions of detention are not driving decisions to die. So first, I want to highlight the rights violation that occurs when MAID and involuntary psychiatric detention are put together. While MAID is not currently available on the basis of a mental disorder alone, this is set to change next year in March. The law was going to come into effect sooner and then has been delayed as the legislature felt it was not yet ready. But the plan is at this stage for it to come into effect, as I said, next year. And even without this contemplated change in the law, people who are subject to involuntary psychiatric detention are already eligible for MAID if they have a comorbid physical or neurocognitive condition like dementia that renders them eligible. And in fact, people who are subject to involuntary psychiatric detention have already received MAID in Canada. There is no actual requirement for data collection on that issue, but we know from some news stories that this is something that is happening. So some people are under the misapprehension that a person can only be involuntarily detained in a psychiatric facility if they lack medical decision-making capacity, but this is not actually the case. So the capacity requirement for MAID does not preclude involuntary patients from MAID eligibility. MAID was designed as an option to relieve intolerable, irremediable suffering that is caused by an illness, disease, or disability. The problem is that it's very difficult for doctors to distinguish between causes of suffering. So if a person has a medical condition and is suffering, it's very easy to mistakenly conclude that it is the medical condition that is causing that suffering. And cases have already been publicized where people have received MAID in Canada because of social feelings like poverty or a lack of housing or other disability-related resources. So this leads to the risk that factors other than the person's medical condition will cause them to elect for MAID, which in my view is a situation that we must resist. So throughout Canada, people with mental disabilities can be involuntarily detained in psychiatric facilities if they meet legislative criteria. And of course, those criteria vary from province to province and territory to territory, but there are some similarities there. It requires that the person have a mental disorder, and generally that detention is necessary to prevent harm to the person or harm to other people. And the criteria can be broader than you might think. It doesn't require that the person is going to physically harm themselves or others. It's enough if without detention, they would substantially deteriorate in a lot of provinces. Involuntary psychiatric detention involves a profound loss of a person's autonomy, and this deprivation of liberty goes far beyond simply detaining a person in a psychiatric facility, which is of course on its own already a serious rights violation. The person can be denied access to the phone and internet, denied visitors, denied fresh air, denied access to clothing other than hospital pajamas, and basically every aspect of their life can be controlled by the facility in which they're staying. Some have commented that the rights that people in involuntary psychiatric detention have are much less than those enjoyed by people in prison. And of course, the rights in prison are not exactly stellar either. People can also be placed in what's called seclusion or a quiet room, which is essentially solitary confinement, but without the safeguards that exist in the context of prison. The person can be physically restrained, they can be mechanically tied to a hospital bed, and they can be forcibly injected with medications if their behavior is difficult to control. And all of this happens with very little oversight. In some jurisdictions like British Columbia, where I work, involuntary psychiatric patients can also be forcibly administered psychiatric treatment, even if the person has the capacity to refuse that treatment. So because of the conditions in psychiatric facilities, the experience of involuntary psychiatric detention can cause immense suffering. And so the problem arises that the suffering associated with detention could result in MAID procedures. As well, the severe lack of choices that is presented to involuntary patients to take control of their lives and change their situation really undercuts the notion that a decision to die in these circumstances could be truly autonomous. And so you'll hear that I'm making very similar arguments to my co-panelists, Trudeau and Kengsha, and I similarly echo that a choice to die in the absence of an option to live a tolerable life is no choice at all. So that's the problem as I see it. What can we do about that problem? So one possible response would be to ban MAID for involuntary psychiatric detainees altogether. However, in my view, this would likely result in discrimination issues, since, of course, the only people who are subject to involuntary psychiatric detention are people with mental disabilities. And generally, a blanket approach like that, I don't think would be charter compliant with Section 15. So my view is that the better approach would be to introduce additional safeguards that would help reduce suffering associated with detention and enhance autonomy. So I want to talk about issues with litigating this issue using a litigative rights approach. And so I think that this would be quite challenging. And this is because arguably such a claim would allege that the government is failing to give involuntary psychiatric detainees the tools they need to guarantee or maximize their right to life, rather than alleging that the government is actively depriving them of their right. So a court could find that there was no state interference to ground the claim. I do think that one could try and argue that this is a negative rights claim. And as was kind of discussed by the panelists earlier, whether a right is viewed as negative or positive depends on how it is framed to an extent. And this was discussed by the Federal Court of Appeal in La Rose in Canada. So with respect to the issue that I've identified, one could argue that the state has interfered actively with involuntary psychiatric detainees' right to life. And this action occurs on the part of both the provincial governments and the federal government. So the provincial governments have legislated a system that causes suffering and severely reduces a person's autonomy through the involuntary psychiatric detention system. And then the federal government has enacted MAID legislation, which represents an exception to criminal prohibitions against homicide and assisted suicide. And then they have made applicable to people who are subject to involuntary psychiatric detention legislation without any additional safeguards. So arguably, this is state action through legislation that is interfering with the right to life. Assuming that this claim is viewed as a claim for positive rights, though, and that the negative rights characterization is not successful, I argue that this is a situation in which positive rights should be recognized. And I think that this is unique in a particular way, and that is because of the special relationship between provincial governments and involuntary psychiatric detainees. So provincial governments are often the ones operating psychiatric facilities. And in this situation, courts have recognized that the relationship between the provincial government on one hand and involuntary psychiatric patients on the other is a fiduciary one. And most notably, that was found in the Ontario Court of Appeal case Barker and Barker in 2022. And leave to appeal to the Supreme Court of Canada was dismissed in that case. So the fiduciary relationship exists here because of the immense power that psychiatric facilities have over involuntary patients, because of the dependency and vulnerability that characterizes the relationship, and because of the statutory obligations that are flowing from mental health legislation. Now, there's quite a high standard to finding an actual breach of fiduciary duty in a situation like this. So I'm not arguing necessarily that this duty has been breached, but what I am saying is that the fact that the relationship is a fiduciary one gives rise to additional obligations on the part of the government under Section 7 of the Charter. Now, of course, there is the concern whenever one raises an argument like this, that someone would say, okay, well, this is opening the floodgates, how are we going to allow this and stop all of these other claims that are going to cause a lot of problems from coming in the door? So what I would say in response to that is that the plight of involuntary detainees eligible for MAID is unique. And this is because of the extreme dependence on the government. which the government itself has directly created via legislation authorizing involuntary psychiatric detention. So they've put individuals in a situation where they have no authority and no ability to take care of themselves. And then they've said, okay, well, really the only option available to you is MAID, and that's the only way out. So in my view, that breaches involuntary patients' right to life. So I would say that in terms of whether this breach is contrary to the principles of fundamental justice, I would say that the legislation as it currently stands is overbroad. MAID legislation does not recognize the impediments to autonomy faced by people in the situation, and it allows for the provision of MAID to people whose suffering is caused by their detention rather than by their illness. So what could be done to avoid a breach? First of all, if this case went to court, I think that, and this was also, I think, discussed earlier about the different roles of the judiciary and the legislature. The judiciary might, say that this law is not applicable to involuntary psychiatric detainees so that they're not wading too much into the policy realm, and then leave it to the government to make amendments. In terms of what legislative amendments could be made, I would say that those amendments would have to reduce detention-related suffering and support autonomy. And so this might look like ceasing the use of seclusion and restraints, at least to the extent possible, allowing people access to fresh air, visitors, and the phone, providing people with the freedom to make low-stakes decisions about their daily lives, like the clothing that they wear, their sleep schedule, and activities that they participate in. And also making serious efforts to discharge people into the community in suitable housing with accommodations and care if that's required. So if those steps were taken and the applicant still chose to proceed with MAID, I would think that we could feel more confident that it was their illness rather than their detention that was driving the application. So that's it for me. Thank you.
Thank you so much, Jennifer. So now we're going to move on to our discussion, Q&A portion. So if anybody has any burning questions from all these three very interesting presentations, just please raise your hand. We also have, just for the speakers, we have, this is being done virtually. So you here can give us if there are anybody from online who's also who might also have a question. But perhaps from the in-person audience, perhaps maybe somebody, yes, please.
Just let me know if you can't hear me. I'm wondering if the judicial dialogue lens to the MAID issue is complicated by the fact that it was a Supreme Court decision that prompted the government to pass the legislation. And now we have all these other cases that are cropping up about it being over-inclusive or under-inclusive. And there may be court decisions that come out that require the legislature to legislate one way or the other because of that. And I'm wondering if this sets up a system where instead of legislating proactively in response to complex issues, the government will just wait to see what the court says in these judgments and just enact what's absolutely necessary and use that as a way to avoid politically sensitive issues. This is kind of what we saw with the same-sex marriage reference, where the government posed a reference question to the court and said oh, is it compliant with the charter for us to allow same-sex marriage? And that was, widely acknowledged to be a way to avoid the political sensitivity of same-sex marriage at the time.
Anybody from the panel maybe feeling?
Sure, do you want me to?
As if she's speaking about dialogue.
Yeah. I think that's a really interesting question. I think it reflects some of the history that I spoke about where there were numerous unsuccessful attempts to legislate a regime. And one of the observations was that members of parliament really struggled to arrive at some of the eligibility criteria and safeguards by themselves. And so when you look back at the history of the evolution of Carter, there was a lot of input from medical ethicists, from physicians organizations, disability rights groups,
and other advocacy organizations as well. And so I think it will continue to be a process of collective shaping. I don't think that some reluctance on the government's part to defer to kind of judicial directions is necessarily a bad thing. I think we are seeing a trend towards, at least in Alberta, I speak from the Alberta experience, some denigration of the court system. We're starting to see some really negative rhetoric about the judiciary and its role. And so I think the extent to which legislatures and courts continue to have that dialogue, I think continues to lead to the thoughtful refinement and development. And that's why I think Carter is such an interesting case study, is because it, looking back, it really gives us an example of how that dialogue happens in practice. So I don't think it's necessarily a bad thing for there to be continued evolution in safeguards that are.
Yeah, so I think that's quite a good question. I mean, there was actually an argument made by some that when the Truchon decision came out, that the government should have used a referendum question about what did you mean when you provided some broad parameters, and that the court could have, and that the government actually could have been more proactive in getting clarity from the court, from the Supreme Court. What I think has happened in a way is that the courts and constitutional litigation has been used as a political tool in this debate, particularly with the Truchon decision. I think, and there has been interesting commentary written about that the Truchon decision, my view, is questionable, or at least raised profound questions about what did the Supreme Court mean, and that even whatever position you take, that the Attorney General actually had the obligation to defend the law of Parliament that had been adopted only 2 years earlier, or 3 years earlier than the Truchon decision, and that they should have asked the question. Okay, so I'm the Attorney General. Yes, I'm also Minister of Justice, but Attorney General Lametti felt, I think, that this was a decision he liked, and they used the lower court decision actually to as a political tool, which I think was actually undermined, in my view, the reasonableness of constitutional litigation, because I think it kind of, so many people have been critical of that, and I think with the reason, if they would have respected the kind of, okay, so here is the lower court, let's see what the Court of Appeal in Quebec says, let's then see what the Supreme Court says, so that we can clarify, was a restriction to an already very broad end-of-life context constitutional or not. And it's interesting, actually, that the authors that you cite, constitutional dialogue theory, actually agreed that the first law was an interesting example of how the legislator interacts in response to a court decision, regardless of what the Supreme Court exactly had in mind, because it's hard to know exactly. It was a little bit of a vague judgment, vague parameters, and no kind of clear instruction about how broad it had to be or not. Anyway, so I think the problem has been that there has been an interaction or kind of a dialogue which was skewed with not a proper respect for the limited role of the courts.
All right. Perhaps, yes, please.
Thank you very much. I was wondering whether the equity concerns that affect voluntariness in choosing to access MAID also apply to other end-of-life decisions that don't relate to MAID, in which there are no legislative safeguards. For example, choosing to refuse life-saving care, dialysis, chemotherapy, because of isolation, because of loss of independence, or someone might say, if I get better, like there's no one around to help me or be with me afterwards anyway, so why should I access this treatment? So is that concern unique to MAID? And if not, what does that say about the lack of any legislative safeguards in any of these other contexts?
You might want to take a stab at that.
Thank you. I think that's a profound observation of just how our society functions. And I think these are claims that we're making at every turn. I mean, our keynote speaker today spoke exactly about this and how it links to and its interconnection with democracy. And we're talking about in the specific context of MAID. So I don't think we can shy away from it. I think the question remains, how can we provide dignified life for all in every situation? And I think, and your question can be extended to maybe, choice of what school somebody should go to, or what sports somebody should play, or, so absolutely, and at the end of the day, I think, so this links beautifully back to negative rights and positive rights, but at the end of the day, what are we really talking about? We're talking about a dignified life for all, hopefully, which, we're asking the government to help in, because not everybody has the luxury of living it. So I'm sorry, it's slightly philosophical, but I'll hand it over to Trudeau.
Yes, so and I think you also try to kind of say, well, should we be uniquely concerned? I would say what we try to argue is, yes, certainly in the context of elder care, people may give up on life even without the presence of MAID. Stop eating and drinking and just let themselves go. But I would say MAID adds to the concern in the sense that if you look at how it has been implemented and how it has been promoted, it has been promoted in a quite aggressive way in terms of the publicity that has been given around it, the ease of availability. So yes, people can give up on life, but when you have in the medical system physicians or nurses proposing that this is an option, I mean, it's the facilitation by which medical support for ending a life pushes people and so we cite in our paper actually the example, which is interesting. Mr. Jean Truchon in the Truchon case actually opted for MAID in the context of COVID earlier than he would have planned, because he feared isolation in a long-term care home. So I think MAID kind of, yes, drives or creates even or confronts it even with the failures of our long-term care system in a very dramatic way, in the sense that people are saying, well, instead of even going to that support, I'm opting out. And that's actually why we criticize certainly also the decision by Justice Senta, where he refers to the modest harm of isolating people in long-term care homes in an Ontario context, where the commercial long-term care homes, not only the commercial, but there is certainly beginning of evidence that some of these long-term care homes, commercial long-term care homes, are seriously lacking in providing adequate care. So you have the failure of our provincial government in funding adequate long-term care home, and then you have the federal government promoting MAID. I think it's the kind of the toxic nature of that cocktail of failure in one area and promotion in another area.
Okay, Anthony.
Thank you. Trudeau, I was going to ask about how I only read the headnote to the case. Just sent to how could the Better Care Act, how could that harm possibly be described as modest? So I didn't see much, but I did have a broader question for the whole panel. I think that there's a neat argument here that I'm sympathetic to, that kind of goes something like this. We know MAID is permissible since Carter. we are now seeing that people might be accessing MAID for the wrong reasons. They're influenced by systemic conditions in things like long-term care facilities or mental health facilities. So there ought to be a positive to address that problem. There ought to be positive rights to improvement of those conditions. And again, I'm sympathetic to that argument, but I think one can imagine like the most serious interlocutor possible here that makes exactly the opposite argument using basically the same premises by saying something like there are no positive rights. Therefore, we're kind of stuck with this toxic cocktail of systemic conditions. People will access MAID for the wrong reasons. It was a mistake to decriminalize MAID, and like they are that could terminate in the claim that MAID's here to stay since Carter, but like we can imagine the Supreme Court changing their mind because they did. So I just wonder what we say to that, as I say, the strongest possible interlocutor who makes that basically the reverse argument that they made here.
Wants to speak.
Your question isn't quite linked to my paper, but I'll just kind of opine on it and let the rest of the panelists dig deeper. But I think there's an interesting tension between systemic conditions and individual freedom, autonomy, choice, arguably a sense of paternalism sometimes as well about what we think other people should or should not do with the choices they make about their own life and access to healthcare, things like that. So I just think it's this panel has really surfaced a really interesting question about how do we navigate that and in what arena do we really address those concerns and how far can we take that. So I'm incredibly sympathetic to the concerns about the quality of elder care. I think that has been a live issue in Canada for a long time, and we're going to continue to see further pressures on that with our aging population. I think the situation is going to get worse before it gets better. We're also seeing a fragmentation of healthcare in Canada, or attempts to kind of ongoing attempts to privatize healthcare, and that has the potential to impact quality as well. But I think that's a bigger systemic conversation that in this case, I think there's benefits and drawbacks to pursuing kind of legislative reform efforts, but this might be a place where kind of a broader view in the legislative arena is where that conversation needs to take place, because I do think it would be challenging to litigate that issue fulsomely in a way that would lead to the desired policy change. So,
yeah, so maybe let me say that I think there are questions of coherence, and I personally think there are questions of coherence about framing a right to MAID as a kind of a specific right, in the sense that it was, one of the key reasons the Supreme Court gave was that they bought the argument that it has to involve support, active support by a physician or an actual physician. They didn't talk about a nurse. And one of the reasons was that they said that people would die earlier because they will end their lives when they're still physically capable of doing so. And so that's one of the reasons why they turned it in, why they recognize that there is a right to support, because otherwise the state forces people to die earlier. I think that was actually not based on clear evidence. That it's an intuitively appealing thing. I mean, certainly in the context of, say, cases of like Sue Rodriguez, ALS, where people physically indeed become unable. So I think it's intuitively appealing, but it certainly doesn't apply so broadly, because if it were the case that made legalization is to address the fact that people will die earlier, because that was the argument. So it's to avoid that people are forced to end their life earlier. And so the legalization becomes a way to protect people against premature death. There is no evidence that the legalization has actually resulted in a reduction of suicide, because that would logically have to happen. It didn't happen. So the jurisdictions where they legalized euthanasia, Belgium and Netherlands, haven't had a reduction of suicide that corresponds with the uptake of euthanasia. So it's clear that it has created a new practice. Anyway, so I don't know if you follow me, but what I want to, so my response to your question is yes, indeed, it's a little bit of a stretch to have said that I mean some of the logical basis of the Supreme Court decision, I think, to some extent has been questionable, and I think it's a complex policy question, and I think it's reasonable. I would buy the argument certainly that it would have been more appropriate for, as they are currently doing actually in the UK. They have lengthy debates, much more sophisticated than we've seen in the Canadian context. So Parliament, the House of Lords now, but before the House of Commons, have debated this issue. They've had parliamentary commissions. We had some of it, but I would say the debate and the public debate and the media reporting and the op-ed pieces in the UK context are sophisticated from all sides in a way that we haven't seen. So it could, I think there is an argument to be made that this is the kind of thing where the issues are so complex that maybe it's, you know, as you cited, Justice Major, I think. So yes, maybe that would have been the best way to do it. I think here, you know, people were frustrated about lack of and constitutional litigation and came about, and where we are. I would say we have to kind of respond in the context of what we've seen, which is a recognition that there is some level of a chart right that has to be interpreted and has to be applied.
Yeah, so I think like your question about, you know, would a court say, okay, the solution to these issues is not to allow positive rights. What we're going to do is we're going to, you know, do an about face and get rid of MAID. It's hard to imagine that happening anytime soon, given that Carter was relatively recent and given the political landscape. I think that there is growing support for MAID, both within Canada and internationally. And for the court to say, you know, we should just get rid of this altogether, I think the issue then is that they would be completely just sidestepping the issue of the suffering that the government is causing through these legislative mechanisms. So they wouldn't be actually doing anything to address that. And they just say, okay, well, we're just going to get rid of MAID and we're not going to address those problems at all. So, I mean, I guess I certainly hope that wouldn't be the way that it would go. And although, you know, perhaps there should be more restrictions on MAID as a system, I don't think that getting rid of it altogether would make a lot of sense, at least in the short term. So maybe that should encourage folks, like if they want to bring claims in this situation sooner rather than later, might be a good time to do it.
Okay. If I may just add last, I think that one of your concluding points is the narrative's important. And I think that that's exactly the point here. I think if the narrative is that, oh, you know, people are accessing MAID for the wrong reasons, the issue is MAID and let's get a MAID. That's not what, you know, that's not the narrative. That's not what we're saying. Rather, what we're trying to say is that there's a question of real choice and real dignity in life and in death. And so the question here is, how do we provide them a real choice and a dignified life so they really opt for whatever they want? That's the narrative. And I think that's the key takeaway that we want others to walk away from.
Thank you. We have a moment for a few questions. Yes, please.
Sure, yeah, thank you for such interesting presentations. Sure. Thank you for such interesting presentations. I'm interested in if a person was to try to bring a claim that involved an argument that some of you have discussed, like the idea that the failure of robust recognition of positive rights to either have high quality elder care or detention conditions paired with a very liberal recognition of negative rights to do anything you want with your personal autonomy, how that leads to like an incoherence where then people don't have the choice to use their negative rights to opt for MAID voluntarily. If someone were to try to present that as leading to absurd consequences, the way some of you have described, I'm wondering if you could talk about, I guess, like what kinds of ideal fact or law would have to exist for one to bring that challenge? Like what kind of legislation would you be challenging and what kind of court remedy would you then be asking for to fill in that gap that you're describing?
Litigation. Anybody?
I think one thought that comes to mind, would be really interested to hear the rest of the panel comment on this too, but some evidence as to the connection of a sense of compulsion or a sense of an absence of choice. So I know there's been a lot of media stories where individuals will say that to find housing, let's say, that can accommodate conditions, and that's led me to consider it as an option. I think there would need to be compelling evidence that would situate those two aspects as connected and inherent in the charter analysis, because otherwise I think there might be some gaps in the logic or the understanding to be able to make that connection. So I do think that sort of causal connection would be.
Anybody else? Okay. All right, so I think that would we don't have any more time, so I want you to please join me in thanking.
Can I comment?
Oh, sure. Yes, true.
No, I was just thinking about the question before that also. I mean, it relates to the last thing also, but that one of the things that one of the thoughts I had also when we were looking at this panel, we are indeed currently constantly debating within a system where MAID is legalized on the basis of some recognition of constitutional right. But I think there is a claim to be made that we never had a Supreme Court decision that looked at, is it appropriate? Certainly when you look at the proportionality principle that applies in Section 7 and Section 1, is it appropriate that we have a system that has been expanded in such a way that a broad segment of the population may arguably be at risk, precisely because of the kind of the failure of reasonable choices, and so I think I hope that with the litigation that is now coming from several sides, including in the context of mental health, that there will be a reflection on, did we go too far? Did we go too far? And is there, if we kind of look at proportionality analysis, and if we look at the evidence that is emerging of why people ask for MAID, that there is a justification to go back to the drawing table and see what were the original reasons why the Supreme Court said, what were the kind of the cases that they looked at. Think about the Rodriguez case, think about the case of Miss Taylor, who was also suffering from ALS. These were exceptional cases, but the practice has been completely, I would say, normalized outside of that. Was that necessary? Was it disproportionate? Is there a way to justify a more narrow analysis and a kind of a more an analysis or legislative scheme that kind of takes into consideration the tension that the Supreme Court recognized, that there is an obligation of the state to protect life for the reasons that we discuss here. That would avoid some of the dilemmas in the mental health context also. So I think there are policy issues to be debated that we haven't really debated yet.
Thank you so much. Thank you so much, everyone, for joining us. On that note, if you have any more pressing questions, or I think many of our panelists will be available, but there's also lunch outside. So please join me in thanking our panelists. We're all done. Thank you.
Yeah.
All right, well, I guess we will get started on this panel this afternoon. So this panel is on Canada in comparison. I'm Brenda Kosman, just chairing here. I'm a faculty here where I'm also Associate Dean of Research and other things. And we have a wonderful panel today who we will be hearing from in order. So first we have Rob DeLuca, who is the still relatively new research associate here at the Asper Center. Previously worked with the CCLA and the Center for Constitutional Studies. Then we have Sambhavi Mano, who I believe is a graduate of this law school, and is currently a graduate student at a little school called Yale Law School, where she is doing constitutional studies. Also clerked for the Supreme Court of Canada before going there. And last and decidedly not least, we have Sanjay Ruparelia, who is a professor of politics and public administration at TMU, where he also holds the inaugural Jaroslawski. I should have asked that before. Jaroslawski Democracy Chair. And so from each of them, we're going to hear about 15 minutes and hear a little bit about the context of Canadian constitutional law, but in a more comparative context, through a slightly more comparative lens. So with no further ado, Rob.
And I should be well within 15, I hope. And thank you all for coming. And yeah, for my co-panelists. What I would like my hope is eventually, maybe more in the Q&A, to address, I think some of what I'm trying to do in my paper is build on some of the themes we discussed this morning, but I won't try to tackle them directly. So the purpose of my paper is to provide a comparative examination of the court's positive rights jurisprudence with respect to the fundamental freedoms, and with a focus on freedom of expression in particular. And my focus is specifically on drawing a comparison with the US case. So I just want to start my comments as to why I think the US example is worth some discussion in this context. So the first point is that if you go back to the early cases with respect to positive rights and freedom of expression and the fundamental freedoms more generally, the US tradition was consistently and explicitly relied upon. And it was generally relied upon for the rule that the fundamental freedoms were basically negative in character. So point number one is simple enough. The US comparison has been relied upon by the court itself. Now, a second reason why I think it's important to highlight the comparison is a more rhetorical one. So in the recent positive rights cases, the court has moved away from explicit discussion of the US comparison while continuing to rely upon these same older authorities. At the same time, the US has gotten more extreme in its negative orientation. Let you fill that in. So my second point is that the US has proven itself to be an uncomfortable example. And since these older cases were decided, the US has deepened what it means to interpret freedom of expression as a negative right. And I think it has done so in ways that are inconsistent with, I argue in the paper, Canadian practice and the Canadian constitutional framework. So my final point is that if one attends to the comparison, and one attends in particular to the comparison between the US and Canadian example, it helps to illustrate positive commitments in the Canadian Charter. And I think it specifically highlights positive commitments that the recent case law has done a questionable job of addressing. So all that said, my starting point is not the US case, but the Supreme Court of Canada's 2021 decision in City of Toronto versus Ontario. And City of Toronto is I think, a necessary starting point because it revisits and reformulates the formal positive rights test for freedom of expression. And just as a reminder, it's a formal test that was first articulated and then deployed in the freedom of expression context in 2007 in Bear versus Alberta. And then the test is mostly sidelined until 2021. So the key fact underlying City of Toronto was that the Ontario government had, in the midst of a City of Toronto municipal election, reduced the number of wards in the city from 47 to 25. If one applies the normal freedom of expression framework from Irwin Toy, there's little doubt that freedom of expression was engaged. If applied, we'd be in the world of a Section 1 justification analysis as to whether the government could justify the limitations of the freedom of expression in issue. So just to give a quick example to illustrate the point, there were councillor campaigns that had already been underway. They spent limited campaign funds and had designed campaign strategies on the basis of the old wards. The new legislation comes in, changes what these campaigns mean, who they're speaking to, basically changing the rules of the campaign. It seems to me very clearly engaging in freedom of expression on what one called the negative rights framework. But the majority very intentionally avoids the Section 1 justification analysis. And it does so by deciding the freedom of expression issue by way of the negative versus positive rights distinction. So in the majority's telling, what the freedom of expression claim was really about is a positive claim about a specific statutory platform, so the 47 ward structure. Because this is an ask for a specific statutory platform, the court's special test for positive rights applies. And I think part of what is important here is the majority's use of the positive rights framework is specifically intended to recognize the extraordinary nature of positive rights claims. So an applicant has to show that the claim is grounded in freedom of expression and not something else, like wanting to access the statutory platform of being a city councillor, and that the government's denial of access or failure to act substantially interfered with the freedom or had the purpose of doing so. So again, just a very elevated standard. So in this telling, the majority is relying on two crucial premises. And the first, and as mentioned, is this idea drawn from prior case law that section 2B has been, quoting the majority, interpreted as generally imposing a negative obligation rather than a positive obligation of protection or assistance. And so the court here is directly relying on its prior jurisprudence, Hague v. Canada, as it was cited in Bear. Now, the second premise is that an elevated threshold for positive claims is required because it narrows the circumstances in which a government or legislature must legislate or act. And this is clearly stated as a separation of powers concern. So in the negative case, freedom of expression has always been interpreted quite broadly, so it is relatively easy to prove engagement. The majority's argument and concern is that if the same rule were to be applied in the positive rights context, the result would be to compel governments and legislatures to justify their countless decisions not to act. So to jump ahead now to the US comparison for a second, I think it's important to note that the distinction between negative and positive rights in the fundamental freedoms context was first made to expand the field for positive rights claims. In Hague, this was conceptualized as a potential departure from the negative US tradition. And an expansion of the right is exactly what happened as a number of panelists noted today in the labor context, the freedom of association context, especially through Dunn. It is an important side issue. I just don't have time to sort of grapple with that in the presentation. But what the court is doing in City of Toronto is actually making it harder for positive rights claimants as compared to if there was no distinction between negative rights claims and positive rights claims at all. So in liminal cases, charter claims can have both positive and negative dimensions. And I think City of Toronto is a good example of this. And what the court's distinction does in practice is to allow courts to emphasize the positive nature of the claim, apply the positive rights test, and then in the ordinary case, find that the exceptional thresholds have not been met. So to summarize, what is driving the analysis in City of Toronto is the idea that freedom of expression is generally to be interpreted negatively, due in part for separation of powers concerns. And this negative rule, again, is drawn from case law alleging common cause with the US tradition. So now I just want to turn to the comparison more directly. And my point in doing so is to argue in part that these older cases drew the wrong conclusion from this comparison. So the first point is that in setting up the First Amendment as articulating a general negative rule, the court was ignoring the complexity of the US tradition. And what I argue is really going on is that the court was drawing on a particular strand of US theory and practice. And this strand in particular is sometimes referred to as negative First Amendment theory, or alternatively, a number of theories that fall under negative characterizations of the First Amendment. So on this view, the chief purpose of the First Amendment isn't these sort of exalted positive ideas about self-government and the practice of self-government and why freedom of expression is important to that, or exalted ideas about self-realization. The purpose is instead to protect against government power and abuse, including government power and abuse that might be exercised through speech-based regulations. But if you compare the First Amendment in Section 2 with this negative interpretation in mind, it argues for adopting a more positive reading of Section 2. So at the level of text, the First Amendment gives a clear model of what freedom of expression as a negative freedom would look like. The First Amendment begins with a restriction on congressional power. Congress shall make no law, and then limits Congress's authority to abridge the right. First Amendment theorists who take a more negative view of the clause have used this language and its context to argue against imputing loftier positive aspirations to the First Amendment. And this includes, I think importantly, that if the positive frame was intended, the First Amendment would be phrased as, quoting one scholar, self-contained guarantees of liberty. But self-contained guarantees of liberty are precisely the language one finds in Section 2. The section is first stated as a broad guarantee. Everyone has the following freedoms. And then the enumeration provides practically no limitations except peaceful. Assembly must be peaceful. Maybe there's more. But so it's notable, for instance, that the majority of City in Toronto begins with very strong language about needing to anchor on the Constitution's text, such as the clear text about provincial jurisdiction over municipalities, but is then to move to a rule of interpretation when it moves to the analysis. Now, a second related point is that the Constitution more broadly imposes several expression-laden obligations upon governments, from minority language schools to religious education to language rights more broadly. And I think, and so for instance, the court has stated that there's no real contradiction between the Charter and its positive enforcement and obligations with respect to things such as language and the idea of liberty, because culture, language, etc., makes possible meaningful choice. And this kind of argument is simply very different than the way the First Amendment in the US Bill of Rights is structured. In the US model, there's a certain level of discretion that Congress and the states have to pass things such as official language laws. But then that discretion is limited by the First Amendment. And just the closing point I want to make is that I think ultimately what this is most in contradiction with is that the idea of a shared negative tradition is very hard, if not impossible, to reconcile with sections 1 and 33 of the Charter. A negative interpretation understands the amendment as imposing specific limitations on government power, limitations that are largely backstopped by courts exercising a strong form of judicial review. And sections 1 and 33 run directly counter to this model. Section 1 provides a clear demarcation between the interpretation of rights and government justification for their restrictions. And so my concern in the paper is that part of what the court is effectively doing is reading down one provision of the Charter, Section 2, so that the government can avoid its duties of justification under another provision of the Charter, Section 1. Again, I'll close there. I have a few more points, but I think that's generally my concern. Now the issue with the floodgates concern, I think, is a separate one that I think for other reasons is less compelling or less an issue that the court sort of makes on. But I think that's a good place to leave the discussion. Thank you.
All right, I want to start by thanking, it's getting late, start by thanking the Asper Center for putting on this excellent symposium. It's been really great to be back at the law school. Conditions were a little different when I was last here. I graduated in 2021, so you can imagine. So it's, yeah, nice to be back and see everyone's faces. So in writing this paper, I was interested in how our Supreme Court has responded to the concern that charter adjudication risks judicial entanglement in inherently and inescapably political issues. I think this ties in quite nicely with the separation of powers issues that we've been talking about today. These concerns about judging political issues have manifested in two main ways. First, as questions about the legitimacy of transferring decision-making authority from democratically elected representatives to unelected judges. And second, in the form of questions about the institutional competence of a court to evaluate the policy choices of the political branches. The idea there is that courts don't have the resources or expertise to determine what policies best advance the public interest. But the counter argument that's often raised in response to these concerns is that the Supreme Court has a constitutional duty to review charter challenges. The court has held that the enactment of the charter transformed our system from one of a parliamentary supremacy to one of a constitutional supremacy. And so it's not the judiciary that limits the power of democratically elected bodies, but the Constitution, which the Supreme Court says must be interpreted by courts. So I call this the institutional tension, the pull between competence and legitimacy on one hand and the duty of review on the other. And just to preface my argument here, my paper suggests that where the court has attempted to manage this institutional tension, it's often done so by affording itself discretion to consider prudential factors in determining whether it should defer to the political branches. And I argue that these discretionary approaches don't actually deal with the questions of competence and legitimacy that are often raised by judicial review skeptics. It might even complicate them further, since the court's prudential reasoning is often the very same type of policy reasoning that the legislature might consider in making the underlying decision. And for this reason, I think that both proponents of positive rights and judicial review skeptics have reason to be wary of the court's recent attempts to raise separation of powers concerns when determining whether the charter imposes positive obligations. This was in Sharma and in the dissent in Fraser. Given how the court has dealt with the institutional tension thus far, I think it's unlikely that this move will help the court actually address the problems of competence and legitimacy. And instead, if the pattern holds, it's more likely that this is going to introduce increased discretion at the stage of determining the scope of the charter right. So let me take a few steps back here. How do our courts confront this puzzle of delineating the boundaries of legal and political authority in charter cases? It's often suggested that our Supreme Court has rejected the political questions doctrine, which is how courts in the US have dealt with the institutional tension. That doctrine instructs US courts to refuse to hear cases that present questions that are textually committed to the political branches or lack clear judicial standards. There's a series of other factors, but those are really the main ones that are in play. But to say that we don't have a political questions doctrine doesn't actually tell us the whole story. Justice Dawson actually has a great book on this, and the idea is essentially that our Supreme Court has at times said that we don't have a political questions doctrine, including most famously in Operation Dismantle. But we essentially do the same sort of thing through other mechanisms. And in this paper, I focus on two of those mechanisms that often come up in charter cases. The first is the justiciability inquiry, which courts use to determine if a question is purely political, such that it's not justiciable. And the second, which may be somewhat surprising, is the Section 1 analysis. So in Operation Dismantle, Justice Wilson referred to Section 1 as the uniquely Canadian mechanism through which courts are to determine the justiciability of particular issues. And I do think there's a difference between finding an issue non-justiciable and not finding a charter violation. But the underlying idea here is that at Section 1, courts consider whether another branch of government is better positioned to weigh the competing interests at stake. So both of these mechanisms, justiciability and Section 1, are meant to help the court deal with the institutional tension. But it's not clear that the court's actual approach to these mechanisms recognizes the competence or legitimacy of the political branches. Instead, the court makes highly discretionary and unavoidably political assessments about the wisdom of judicial intervention. So turning first to the justiciability inquiry, unlike the US political questions doctrine, which asks about textual commitment and judicially manageable standards, the Canadian approach to purely political questions is openly discretionary. The Supreme Court emphasizes that justiciability inquiry is a matter of judicial judgment or judicial discretion. And it has stated that this judgment or discretion is to be exercised in accordance with the court's own understanding of its position in the constitutional scheme. But the court doesn't necessarily exercise that discretion in the way that we might think, given the institutional tension. The court's justiciability jurisprudence is marked by a peculiar paradox. On the one hand, some of the court's most searching inquiries into justiciability have arisen in reference cases, where it has a duty pursuant to the Supreme Court Act to answer the questions that are referred to it by the governor and council. And we might think that the institutional tension lessens in cases where the court's originating statute says it has a duty to answer, and the political branch has asked it to answer a question. But the court has applied the justiciability inquiry with full force in these cases. And it's in fact relied on political considerations to refuse to answer reference questions, including those relating to the charter. A really good example here is the same-sex marriage reference, where the court refused to answer a charter question in part because the court thought that its own answer to that question wouldn't further the government's goals of achieving uniformity in civil marriage across Canada. This seems like a political consideration. In fact, it's exactly the type of thing that the governor and council might consider before deciding whether to pose a reference question in the first place. But the court substituted its own judgment regarding the wisdom of posing the reference question for that of the governor and council and declined to answer. So that's what we have on one hand, this sort of strange approach to reference cases. And then on the other hand, in positive rights cases, where the institutional tension is probably most salient, we might expect the initial stopgap of justiciability to feature heavily in the court's jurisprudence. But the Supreme Court has actually resisted attempts by the government to immunize such claims from judicial review. I'll just give one example here. In the Native Women's Association of Canada case, the court considered a failure to consult charter challenge. The NWAC argued that the federal government's failure to fund their participation in constitutional reform discussions violated their charter rights. The federal government argued that the underlying issue in the case was non-justiciable because it was about consultation. And the court did characterize the NWAC's claim as a positive obligation argument about consultation. But in a somewhat puzzling move, the court held that the justiciability argument was a subsidiary issue that was unnecessary to address, given the court's ultimate rejection of the positive obligations claim. But there's a difference there, right? The effect of a finding of non-justiciability is to decline to review the final decision of another branch of government. A charter analysis necessarily subjects that decision to a further level of review. So by asserting its authority to review the government's consultation decision, the court designated its own reasoning and not the government's as the final say on the matter. even if that final say was to allow the government's decision to stand. And as with the reference case example, the court relied on precisely the type of policy reasoning that the federal government would have undertaken in making its funding decisions, including evidence of whether the groups that were actually funded represented the views of Indigenous women, and evidence of the opportunities that the NWAC had to express their views. So what we see in both reference cases and positive rights cases is that when the court asserts a discretionary power to declare the boundaries of its jurisdiction, it runs the risk of designating itself, rather than the Constitution, as the final arbiter of that boundary between legal and political authority. And we see the same problem again in the Section 1 analysis. Plenty of scholars have written about how the Oakes test requires courts to undertake precisely the type of policy reasoning that we're told belongs with political branches. And this is exactly why concerns of institutional competence and democratic legitimacy are an uneasy fit at the Section 1 stage. How is the court to determine when it should supplant the legislature's balancing of competing interests with its own? The Supreme Court made some early attempts to give the deference analysis some doctrinal form, but it eventually landed on a contextual, free-form approach to deference. But if Justice Wilson was right in Operation Dismantle that the Section 1 analysis is where we're supposed to deal with the institutional tension, the way we do deference has become entirely untethered from that foundation. This contextual approach doesn't recognize the institutional competence and legitimacy of the political branch in certain areas. Instead, it relies on differences in context to confer discretion upon courts to determine on a case-by-case basis whether they should supplant the policy choices of the political branches for their own. I walked through some examples in my paper, which I'll skip over in the interest of time, but I'll flag that Section 15 cases involving fiscal considerations are an excellent example of this. Sometimes the court is hesitant to second guess the legislature's budgeting decisions, sometimes it's not, and it depends on the context. And whatever we might think about whether courts should be engaging in this kind of reasoning, at minimum, I think we can't say that the court's approach to deference at the Section 1 stage is actually deferential to the competence and legitimacy of the political branches in certain areas. So where do we go from here, and how does this all connect to recognizing positive rights in the future? I think the takeaway is where the court has engaged with the institutional tension, it hasn't actually deferred to the institutional competence or democratic legitimacy of the political branches in particular areas. Instead, it has afforded itself discretion to rely on political considerations in delineating the boundaries between legal and political authority. And for that reason, I think that both proponents of positive rights and judicial review skeptics should be concerned about the court's recent attempts to raise competence and legitimacy concerns at the charter rights stage. So in their dissent in Fraser and majority judgment in Sharma, Justices Brown and Rowe warned that to interpret Section 15 as imposing positive obligations on the government would pull courts outside their institutional competence and into the complex legislative domain of policy and resource allocation, contrary to the separation of powers. Now, I'll note that this is probably one of the clearest articulations of the concerns of institutional competence and legitimacy that we see from the court. Justices Brown and Rowe go on to tell us that courts are ill-equipped to grapple with public policy and budgetary complexities, that only legislatures have the institutional capacity to assess how resources should be applied, and that courts shouldn't fiddle with the complex mechanics of legislative schemes. But the court hasn't hesitated to fiddle with some of the most complex legislative schemes in the past, including budgets. And it's really quite difficult to think of a Section 15 decision that doesn't pull courts into that complex legislative domain. So this isn't really a problem that's unique to positive obligations. It looks like even traditional rights claims can pose this risk. But then how are courts supposed to determine when they're impermissibly within the legislative domain? Maybe the court will develop a principled distinction here, but given what we've seen with justiciability and the Section 1 analysis, I think it's more likely that this will carve out a space for judicial discretion in positive charter rights cases. Something like a case-by-case determination of whether a particular interpretation of Section 15 would pull the court over an indeterminate line of policy reasoning. So I'll leave it there. Thank you very much. I look forward to the discussion.
So far, you folks are making my job real easy. Everybody's under. Last but not least.
Oh, I have to. Do I use this to, yeah. So thanks to David and Cheryl and Tal for inviting me to participate in the symposium. I heard Kent Roth say that he was an interloper on that last panel he was on. And if he's an interloper, then I don't know what I'm doing there. I'm not trained in law. I don't work on Canada. I'm a political scientist who is trained in comparative government and political economy and democratic theory. But I was pulled into this whole field of constitutional law because of a project I began over a decade ago looking at the construction of new welfare systems in the global south. And around that time, I read Ron Herschel's book Towards Juristocracy and was quite provoked by the thesis because it didn't seem to apply to what I was seeing in India, where I've worked for 30 years. But then also South Africa, even China, if you can believe it, and some of the dynamics about how the courts were working in the field of social rights, social economic rights. So that's what, in a sense, is the backdrop to this entire project. The synopsis is really about an entire book. So one thing I have to do for the paper is really make it manageable. And what I'm going to focus on is the Indian case, which is the one I know best. So the place to understand this project is, within the social sciences broadly, since the 1980s, there's a general view that what we have is a new paradigm of social welfare, which is based on neoliberal lines. And it has three basic pillars: privatization of the provision and finance of various social services, decentralization, and particularly the idea of corporatizing the state, and thinking of the state as a corporate entity and should work as a business model, and particularly increasing and targeting of social entitlements, often means tested. And this has led to this phrase, an unholy trinity, is by the Marxist geographer David Harvey. He says, when you think about the neoliberal era, there's three things that really that strike you. One is the emphasis and the rise of rights-based constitutionalism, I guess what lawyers call new constitutionalism, which Herschel said led to very conservative juristocracies from the 1980s onwards. The second is this emphasis on transparency and accountability, but very much a pro-business good government agenda that the World Bank embraced in the 1990s, which castigated politicians and bureaucrats as very much the enemies, of good, effective, efficient governance. And the third is the rise of NGOs and new social movements at the expense of traditional organized labor, right? So this is a very kind of typical left-wing critique of this period. And what struck me about it was a lot of that literature is based on what happened in the North Atlantic world, not so much on the South. And in the South, what we saw was quite a significant divergence, or at least a more complex story about the role of courts, law, and constitutionalism in this period, where actually it was a lot of figures on the left from a socialist tradition that were using the courts and the language of rights and law to push a lot of claims. If you think about the construction of welfare states in the North, if you read all the classic literature, it's hard to even find an entry for courts and law in the index. It's just not there. I mean, you read about the New Deal, and there's that moment there, right, where the court is involved because FDR is trying to overrule the court if it's going to block its New Deal legislation. But otherwise, the courts and law are not really seen as they're seen as only a hindrance. So either they're missing from the story or they're a conservative obstacle to overcome. And yet in the South in this period, the courts are where a lot of the action really is. And again, by progressive social movements are going to the court. And then the third is a different state building project. So the project that I'm doing, in fact, there's a fourth country in there, which is China, is looking at this broad shift that you see in the global South. And it's trying to say two levels of analysis. One is, why do we see a more progressive, although complex trajectory in the South vis-a-vis the North? And then why do we see very different outcomes within the South? And the big takeaway is the most progressive outcomes have happened in Brazil, South Africa probably second, and India third, but there's cross-cutting trajectories. And the general argument in the sort of larger book project is what we see in these new welfare regimes in this period is what I call a post-neoliberal order. Courts and constitutions are important resources for a whole range of reasons: to seek legal redress, judicial precedent, mobilize social action, incentivize electoral politics, change law and policy, and I would say even administration, and shape public discourse. But over time, and these are three huge countries, this is a 50-year sort of project, you can imagine there are lots of ambiguities and tensions in terms of the outcomes. And what has happened, particularly in the last 15 years, is something that I don't think anyone saw 30 years ago, is the rise or the shift from a rights-based approach, looking at what government and the state is supposed to do in terms of, purposive social action, to relying on market-oriented mechanisms of cash transfers, authenticated by biometric ID cards, and so on, which has led to a new form of welfare in all of these countries, which has created, according to a lot of critics, new forms of commodification and exclusion. And in all three countries, we have also seen the rise of an authoritarian populism over the last decade. It's been defeated, at least set back in Brazil, and to some extent in South Africa. In India, it's in sort of full form right now. And an exclusionary form of nationalism. And part of that, critics say, has to do with the failure of this rights-based approach to social welfare to take on some of the other issues that have fueled authoritarian populism in the South, and particularly rising economic inequalities and the lack of labor-intensive growth. Right? So that's the big argument. So the Indian story is the one I'm going to try to talk about. Crucial developments happening in the 1970s, particularly after the emergency, this 2-year period of authoritarian rule, which in India, being India, ended with an election, and Mrs. Gandhi obeyed the result. And two major reforms, innovations. One is the Supreme Court of India began to reinterpret Article 21, which is a fundamental justiciable right, the right to life, through the directive principles of state policy, which is a non-justiciable, non-enforceable section of the Constitution, Part 4. And what it began to do was to see these directive principles of state policy, so right to education, health, housing, and so on, as before it was seen as very much a subordinate to the fundamental rights, civil liberties, and political rights, but it began to see them as co-equal and read the social and economic goals of the state as through the Article 21, through a sort of fundamental right approach. So there's a substantive reinterpretation of what is the right to life consist in. And the second was a set of procedural innovations, which led to an upsurge of public interest litigation, where the court relaxed norms of standing and pleading, so you didn't have to suffer injury yourself. It practiced suo motu jurisdiction and continuing mandamus, so appointing monitors and issuing orders over a very long period of time on particular cases. And most controversially, just given the last presentation, even assumed executive powers in many cases. And by the 1990s, this always shocks people who don't know India. The court in the last instance is the one that decides who is appointed to it. The Chief Justice, the Prime Minister, and the leader of the opposition meet, the collegium sends forward recommendations. And up until this new government of Narendra Modi in 2014, it's really the court in the last instance that is the final arbiter and who gets appointed to the court. So very controversial, very powerful court that emerges, and has a number of phases. Initially, it's civil rights abuses from the emergency. But then very quickly, by the early 1980s, it's about socioeconomic deprivations of informal workers, so a series of cases. And by the 1990s, the court takes on questions of corruption in political society and the state. And what's very striking is a lot of the movements, a lot of the organization of public interest litigation is led by, of course, lawyers like people in this room, but also former judges like Mr. Tarkunde, who is a judge in the Bombay High Court, who leaves the court, sets up the PUCL, the People's Union of Civil Liberties, and it becomes a really important actor in this story. And one scholar, Rajni Kothari, says that these non-party political movements are the midwives to judicial activism. So this is a really key part of that story. The achievements have been significant. A lot of rulings that are landmark rulings of the Supreme Court, some are conditional in terms of conditional social rights. This is Madhav Khosla's terminology. Some are systemic in the way the South African court has issued rulings. Mobilized very important progressive coalitions, and in many cases pressured administrative reform and even policy change. And if you think about the impact of a court, we often think about remedies as direct material impacts, but they're indirect material impacts. They're also long-term direct and indirect symbolic impacts of the court. So changing public discourse, mobilizing public opinion, bringing new people into the conversation. The limitations of this approach in the 90s and into the 2000s was relatively few public interest litigation cases that come before the court. It chooses what it wants to hear, of course. Few direct remedies. The rulings became particularly inconsistent on social and economic rights after 1989. And the questions we just heard about, somebody just talking about, well, what is the capacity, legitimacy, and accountability of the judiciary itself? I'll save some comments for the end, try to be a bit provocative. I think the legitimacy question is certainly one that's perennial. The competence question, I think, needs to be sort of looked at a bit differently, given I've studied democratic politics more than I've studied courts. And I think with the competence of many governments we've had in many countries, and the ways in which our electoral systems could have distort political representation, I think that question of competence is something that is worth sort of looking at a second time. So one of the more recent judgments about how to think about the Indian court, this is of a volume Sudhir Krishnaswamy and Joe Rosenberg edited a few years ago, said, sort of playing on Rosenberg's idea of a hollow hope in the United States, that the US Supreme Court was a hollow hope for people looking for progressive justice. In the case of India, it's very much seen as a qualified hope. There are cases where, or places, domains in which the court has been very effective and progressive, and others less so, and they try to explain why. I'm just going to show you some data to end. This will give you a sense of just how important the court has become. So the figure on the left is about the number of cases the Supreme Court of India deals with. This is graphed till 2005. The number you want to take away is the pendency, the yellow line, to over 20,000 cases before the court in 2005. That number today is roughly 80,000. Kind of shocking, the backlog on the cases. And then the figure on the right, the color you can't see is yellow, which is writ petitions, which is really the mechanism for socioeconomic rights, public interest litigation. You can barely see it. It's less than 1% of the cases before the court. That all said, one of the reasons I think it's been very important is not simply what happens in the court, but what the court does for civil society. So one of the most important movements in India in this period was the right to information movement. And it began as a right to food movement. But because of those significant rulings of the court, seeing socioeconomic entitlements through the right to life, Article 21, it began to use that as a motto of its own movement. And the picture on the right is, if I know, I shall live, right? So this is sort of linking right to information to the right to life of Article 21. And it even picks up the legal imaginaries of the court. So this is basically a public audit taking place in a village, which is trying to recreate a kind of court proceeding of what is the evidence that the government has actually given the entitlements to these villagers that they were due, right? So this is one way in which you begin to see the radiating effects of this kind of judicial activism. I'm going to run out of time, so I'll end before before the slides do. But what is interesting is that the limitations of the court lead these social movements to go back to electoral politics. So there's a whole series of them. In the 1990s, they're listed on the left-hand side. They convinced the Congress Party leader, Sonia Gandhi, to take up their cause. She's in the middle there. The man to the right of her was a former Prime Minister, Manmohan Singh. And they captured power in 2004 in an election in India, and they legislate a new social welfare architecture. And what's striking about this is if you see all of those bills that are on the left-hand side use the language of rights, their legislation for new social entitlements, so they're drawing on former policies, but they're kind of making them legislative acts, statutes of parliament. And they're explicitly designed to keep the judiciary involved, to scrutinize whether the government is discharging its obligations. I'm going to run out of time here. One of the things we see is that the right to information is very, very popular, but it recreates the problem facing the court, which is that more and more people are putting forward petitions, demanding information on what government is doing, and that itself leads to a backlog within the right to information system. I have 30 seconds. So what's happened in the last decade? I've mistimed this. We have a new leader in power in India, Narendra Modi. He's very critical of rights-based welfare. And instead, he's pushing bank accounts, cash transfers, all authenticated by biometric ID cards. So there's a new system of kind of surveillance. There is greater efficiency, so to speak, but there's also all kinds of problems of inclusion and exclusion that happens in this. And this is what we see play out. South Africa is the country which really leads on this during under the apartheid regime, where the surveillance system and biometric identification is crucial to that order. And you begin to see it playing out in India in its own way, and of course in China as well. And this is what we see in the last decade is the decline of rights-based welfare and expansion of cash transfers. The court abdicates a lot of its responsibilities. I'm sorry, I've mistimed this. And what we have today is the fact that the new government is even trying to now undermine the legislation that created this new welfare system. So that's this last slide. This happened just with the last 2 weeks of undermining the right to work in one of those pieces of legislation. I'm sorry I went over time, but thanks.
I have never had such a well-behaved, timely panel in my history of moderating. We're exactly 30 seconds over. It barely qualifies as lawyers. All right, so we have some time to open for questions and comments to the audience. And David.
Shall I begin?
Yeah, absolutely.
We have a mic, so for people online, they'll.
Right.
Let me do it from you.
Yeah, it turns.
Yeah, it's good. It's on.
Is it? Yeah, it is.
Okay, David Schneiderman, I'm here at the law school. Rob, so it's an interesting story you were telling. My reading of the early UB cases and American references is that they were never part of the reasoning. They were just kind of in the background. They get incorporated and sometimes rejected. But the court doesn't want to be seen to be following American First Amendment doctrine for constitutional identity purposes, right? For legitimacy purposes. And of course, that's fallen off, as you noted. I think there's more going on in the background than whether the court adopts or rejects American First Amendment doctrine. And it's part of the Anglo-American tradition, right? About separation of powers, judicial anxieties about social rights, the American versus the French Revolution. The American Revolution is not about the social question, and the French is, and we've kind of kept the social questions out. And the drafting of the charter reflects this significantly. But I think you're right to point to perhaps Section 1, but Section 33, because Section 33, and Kent Roche has made this argument at length in his book on dialogue theory, Section 33 should embolden courts, right? They should feel that they can actually do things that in the old Anglo-American tradition might not actually be plausible or tolerable. So I think the Section 33 thread makes a lot of sense. But I just wanted to note that the story about American jurisprudence is we followed some of it, some of the rationales for freedom of expression, perhaps. Marketplace of ideas comes out of Holmes and stuff, but we've also eschewed, right? So Keekstra and some other cases suggest rejecting that tradition. Sambhavi, I'm wondering, since we don't have a political questions doctrine, was the point that the prudential approach the court takes looks like a political questions doctrine? Bickel called political questions one of the passive virtues, right? The court can decide not to decide. It seems to me that's what the Supreme Court of Canada is doing in many of these cases, right? It's this exercising the same kind of passive virtue. So I think that was an interesting comparative element. And lastly, Sanjay, that was an interesting comparison. Of course, India, South Africa have textual directives, figuratively and literally, as does Brazil. Brazil is not a great model because it's so individualized. The remedies are not systemic, unlike the Indian case. So public interest litigation, right, the opening up standing seems to me to make a big difference, right, to the way in which courts can be invited to do this work. I'm thinking of the Colombian Constitutional Court, which also hears these tutela petitions, right? Like tens of thousands of them. And of course, there are textual elements in the Colombian Constitution that allow them to do some of the work. That certainly, those petitions can make a difference. But I had this question, and that is, how are courts responding to Modi's semi-authoritarian tactics, right? If the judicial branch has this independence and appointment procedure that separates the judicial branch from the political branches, more so than many other jurisdictions, right? Can they push back? So I'm wondering what your reading of the Indian judicial scene is.
Okay. In the order in which it was asked, maybe?
Yeah, so I thought maybe, but yeah, no, I think I guess a few things. One on section.
Sorry, does he need the mic?
Yeah, okay.
under image.
Okay, thanks.
I mean, section 33, I agree. I mean, I think it was sort of the final closing part that I didn't get to, so I agree completely. And I think it's sort of the combination of 1 and 33 together really promote this idea of then constitutional dialogue that is very hard to square with the American idea. I think the evidence I use is that in particular, the positive rights cases and the sort of American framing or the American discussion. Fair point. I don't think it's part of the holding, as it were. Or it's not part of reasons for decision, but the sort of part of it is the obsession and the way in which the Canadian departure, apparent Canadian departure from the American case, is such an obsession in these earlier cases, including things like Heagstra. That there's often so if you like in Hague, the idea that we're going to start talking about, including because the applicants had pled in this way, of a kind of a 200-year history, but that seems to be fraying, and so we need to think about positive rights because this history is sort of problematic, and including by expressly going to American texts and authorities, and then developing the sort of Canadian model. So my argument principally is that the American case is something of a launching point, and that kind of has informed the discussion as if there is this bias towards the negative conception. And so that's the Hague case. And part of the reason I'm emphasizing this is if you go to Bear, which is the citation in the City of Toronto, it brings you back to Hague and it brings you back to Delisle, which City of Toronto actually omits. But and then in that case, there's that then refers us back to like Big M, this conception of freedom as the absence of coercion and basically the absence of coercion and restraint. And I think that, part of what I'm trying to sort of distill here is that is a very American way and a very kind of classic liberal, I guess I'll say, that was very prominent in the kind of American founding and framing that just seems to me very out of step, not just with the charter, but also with, the Constitution Act 1967, including the language we use and a number of the authorities. And so that sort of emphasis and that use of sort of the American case is the way in which these issues are discussed, even when it departs from the tradition. And it kind of has given an unduly negative bent to how we sort of have thought about, well, how does the positive rights issues come into play? And I think it's sort of this, it's kind of been a weight or a kind of anchor weighing the court's traditions down, and that's partly why I think it sort of placed the entire trajectory somewhat on the wrong step. So that's kind of the way I read them. So I think partly, absolutely point taken. You're right that it's not part of the whole. I do think it did play a very large role in how the issues were discussed, including in the 2B context also. That's how I read it.
So yes, that's exactly right. I think my point is actually that the version of the political questions doctrine that SCOTUS uses is actually maybe more rights protective than the one that we have. they follow Wexler's approach. Like the idea that there has to be like a textual commitment to another branch in order for the court to avoid hearing. And the Supreme Court is doing exactly what Bickel wanted courts to do. The idea that Bickel forwarded was that courts should be concerned about protecting their own legitimacy and should be, turning to prudential factors to avoid hearing cases if that would protect their legitimacy in the eyes of the public. What's interesting in the US context, though, is that there is a lot of scholarly work coming out now that says that there's a difference between how SCOTUS does the political questions doctrine and how lower courts do. So they've observed that lower courts are doing something more like what Bickel was advocating for. And they note that SCOTUS has control over its own docket in a way that these lower courts don't. And I think there's something to say about that in our context as well. Lower courts are much more willing to use the justiciability framework to avoid hearing positive rights cases here. So yeah, that's what I'll say about that. I think it's a great point. Supreme Court is doing exactly what Bickel would have wanted a court to do.
Thanks for questions and also observations about the comparability of the cases. I take your point on Brazil, so the system is different legally and therefore the outcomes imagine be different too. How did the Supreme Court of India respond to Modi? So you have on paper one of the most powerful courts in the world. And after 25 years of coalition governments, it had really acquired an incredible amount of power and authority. Also controversy and criticism because it was exercising its clout. Initially, in the first 2-3 years, it really stood its ground against Modi, right? So there was a bill passed to change about how Supreme Court judges were appointed to give more power to the executive. The court struck it down as unconstitutional, as violating judicial independence, and most legal observers in India said that it was a good judgment. It wasn't just protecting its own power, but it had good reasons to issue that ruling. It then declared the right to privacy as a fundamental right, which was crucial in this period of authoritarian populism, which was rising in India. So those were sort of 2 or 3 important judgments. There were some others too, but then it really kind of neglected things. So Gautam Bhatia, who's a constitutional scholar, but also Supreme Court lawyer in India, put it, I think, really succinctly well. He said, if the 1990s gave rise to the fear of judicial overreach, under Modi, what we've seen is a danger of constitutional abdication. And the court really, in a sense, sat on cases and didn't hear them, right? So the one I ran out of time, it was the Aadhaar case, the biometric ID card, which is very controversial. The court took 6 years. It said some interim orders, but it took 6 years to hear the case. And by then, 900 million Indian citizens had this card. And the case was about, should this be mandatory to receive social services? But once you rolled it out to 900 million citizens, and the bureaucracy has been charged by the executive to say you cannot get your food rations unless you have an ID card, and this is the information we're going to collect. And there were concerns about privacy, the security of the data, the technology, and so on. It was kind of rendered moot, right? The facts on the ground had changed. And so I think, and then there was an extraordinary moment in 2018 where the 4 most senior judges of the court issued a press conference, try to imagine this, where they accused the Chief Justice at the time of manipulating the assigning of judges to benches. Because in India, a lot of the benches are 2-3 judge benches. The full court now is 35 judges. It's lots of cases, hundreds of thousands of cases they hear daily, weekly. And the implication was that he was doing it at the behest of the executive, that he was assigning certain judges to certain cases to get a favorable outcome. So it was a huge scandal and outcry. The other thing the executive did was it sat on the memorandum of understanding about how judges would be appointed. So like I said before that, the court had incredible influence in who was appointed to the court in conjunction with the Prime Minister and the Leader of the Opposition. What ended up happening was Prime Minister Modi just said, fine, you're not going to play ball with me. There are all these nominations put forward and they just sat on them. So judicial vacancies went up. He did the same thing in the tribunals for the right to information. So what you saw was executive interference, sometimes neglect, budgetary cuts and all these programs. And that's what the executive essentially did. It began to squeeze this whole rights-based architecture. And the court now has found its voice again after the pandemic, because there were so many egregious failures in the second year of the pandemic that again, people having given up on the court in some ways went back to it. So it sort of found its voice, then it sort of lost it again. So what you see is a lot of waxing and waning. These are lots of details, but in a sense, the court has, because of the nature of the history of India, since the emergency, it's the politicization of the judiciary and judicialization of politics, the two sides of the same coin. And it's playing out now, I think, as we're in the year 11 of this government. And so the court again is finding its voice, more particularly now that it's a minority government. So that has something to do with how much fragmentation there is in the system. But the reason I found the project interesting was, most of the theories of why does a court acquire a lot of power, none of the standard reasons really fit the Indian case well in terms of the timing of the court. The court really begins to assert itself in the early 80s. So a standard political science argument is if you have electoral fragmentation, a court might acquire more power. But the 1980s were the largest majority governments in India. So I think that what I find interesting about the Indian story is that it doesn't fit our standard comparative theories very well about when and why does a court assert itself. And I don't know of another case of it beginning to reinterpret its constitution in the way it did. And it might have a lot to do with the text and the directive principles, and it has that as a resource. But I found that quite intriguing. And again, this was provoked very much by Ram Hershel's thesis, where I thought, India was another court in a Westminster style democracy that he's writing about. But it doesn't really follow the path that he says happened in the other four cases he looks at. And so why is that?
I'm just going to use my role in the chair for a second just to do a follow-up on this. So I've done a bit of work around the Indian Supreme Court, and I'm just finishing a book right now on its current approach with secularism. And so I have to say, I'm kind of surprised. Would you still see a qualified hope? Because if I look at what's happened, particularly since about 2018, 2019, so there's not only the kind of rise of a kind of autocratic legalism, they constantly are just giving more and more powers to the center, to the executive. And so I'm curious about this idea that it's found its voice again, because it also seems to be deferring and refusing to hear a huge number of really significant cases, right? Like the Citizenship Amendment Act and the Unlawful Activities Act. Like they're just refusing to hear this stuff.
Yeah.
And then when they do decide some of the cases, particularly this is the secularism ones in particular, they are just rolling over to the government, right? They're just, everything is just, whatever the government wants, it seems to be, including like the Ayodhya case, just a little bit controversial, 1,000 pages, just unheard of, 1,000 pages, including this like anonymous addendum, where they're just kind of really just seemingly just rolling over to the majority government. So I would love to hear more qualified hope with this court right now, because I'm not seeing it.
No, so you're absolutely right. So I should have specified. It was on social and economic rights. It was not on
exclusively.
The
okay.
Yes, yeah. Okay. No, on that one, that's the worst abdication that they've seen. Like you said, and the most recent judgment, there are thousands of people under trial. The most recent case was, the former student who they have accused of sedition was sitting in detention, waiting trial for 5 years. The Supreme Court, after 5 years, said we're not going to hear the case. Why? I'm absolutely right. So on the question of secularism, minority rights, it has abdicated. No, I was just focusing on.
Okay. Yeah, so your qualified hope was qualified.
Qualified hope, and I should say that it was in the question of socioeconomic rights, where I think that's in a sense the framing of the inquiry that I began with, not on questions of
everything else that they're doing and not doing. Yeah.
Yeah.
Right. Okay. Other folks, questions, comments? What do we have from the audience? Nothing? I will continue to use my position. You can jump back into David.
You go ahead.
So this is for Sabavi. So, and this is just a small point, and I think you actually address it a little bit in your paper. But I was just wondering whether you can really rely very much from the same-sex marriage reference on what the court said there about why it wasn't gonna answer. The court was pissed, right? Like Beverly McLaughlin was furious, as far as I could tell, with this, like the hot potato that was same-sex marriage. The government had handed over 3 questions, right? And then there's a kind of internal government change. The Chrétien government becomes the Martin government. They don't want this to happen during an election. So they add another question and they add a question. The 4th question, again, it got added and it was really then asking all about, like, does same-sex, like, does the opposite sex definition of marriage violate the Constitution? And so, you know, my read of this was just that the court was quite angry to be pulled into this. And if they wanted an answer to that question, they could have appealed, and they didn't appeal. So, you know, I think that the last one, you know, the reason they weren't answering is that, you know, undermine the government's stated goal of achieving uniformity, like a kind of political thing. She was throwing a bunch of reasons in there, but she just wasn't going to answer this because this, like, should not have been, you know, she's just pissed. Now, I know, you know, judicial pissed offness is not an official test that tends to be recognized, but I do think that there was, so I worry about reading too much into that particular one.
Right.
And you kind of, I mean, you sort of a little bit after you point out.
Yeah, I mean, the reason that I like bringing that example up is because it is on paper so egregious.
Yeah.
But it's true, the court refers to a bunch of other factors, including the fact that the government could have appealed Halpern and chose not to.
Yeah.
But I think that the court had room to be angry about that and express their anger about that because of how much fuzziness is in the justiciability inquiry. There is something to be said about, like, the Bickle approach to doing this and how sometimes it can be beneficial for the court to be able to pull in things like this to say that an issue isn't justiciable. But I worry about the lack of predictability that arises out of that. Like, there's a difference when the government has posed a kind of bad faith reference question. And when you have a charter litigant who is raising a potentially positive obligation case, depending on how the court wants to characterize it, and they won't really know until they read the court's judgment about whether that issue is going to be justiciable. I will say that the court has generally not liked applying the justiciability inquiry in charter cases, but we do have this problem with now lower courts who also have the use of this very flexible doctrine, using it in exactly the way that it was intended. So, yeah.
On the follow-up to that, I can't recall the question they didn't want to answer. Did it have to do with?
It was the opposite sex. Does the opposite sex definition of marriage violate the Constitution?
It was the common law opposite sex definition.
That was the question.
That was the question. And that, I mean, that was what was at stake in Halpern in general.
Right.
And so the government, the feds decided not to appeal. And they drafted a new law, the Civil Marriage Act.
Yes.
They were sending the Civil Marriage Act for review, right?
I read all these things.
I know, just don't remember any. Yeah, yeah.
But I asked the question only because I liked your point that political questions doctrine, the American tradition is a little bit more transparent than the Canadian when you have factors. But the other element of it that I think is valuable is that the passive virtues in political questions and standing and these kinds of threshold jurisdictional questions, American courts consider allow room for the political branches to do constitutional work. So Canadian courts don't think of the political branches as actually exercising sort of their judgment about constitutional questions, right? And they're confronted with these all the time, of course, internally in the course of drafting legislation, among other things. So there's a shared responsibilities. Benjamin Perriman talked about this overlapping separation of powers idea. It's that, right? And the same thing happens here, but there seems to be no acknowledgement that, in fact, that is occurring. And instead, you get governments deferring to courts, sub judice, so I can't say anything about it. Everything, it's the old Michael Mandel, and you might not have read this thesis, and Ron Herschel's channeling Michael Mandel. It's about passing all these political questions off to the judicial branches. And it encourages the political branches to deny that they're actually engaging in this kind of work. And they are. And so I think that that's something worth emphasizing, right? That we need more transparency. And it goes back to the first panel. Anthony Sangiuliano was talking about these normative questions that are under the surface. There's no truth in advertising in Supreme Court of Canada and other judicial decision making. It seems to me they do things and don't say why they're doing them. And so I would prefer, as a teacher of this material, to have more honesty about these things. And the thing about Ron Herschel's juristocracy, there's only so much I should say about it, but I think so he writes about Canada, Israel, New Zealand, and South Africa, right? So India is not part of the equation.
It's on 2 footnotes.
Yeah, exactly. So that's interesting, right? He must have explained his selection of cases. That's something that he would methodologically want to do. But it's interesting because the thesis that all these constitutional orders have constitutionalized neoliberalism doesn't really fit the Canadian case so well. Actually doesn't, though he devotes a whole chapter to that. It fits the Israeli basic law story reasonably well. He knows that story. Right? It doesn't fit the South Africa one so well, you know, in terms of the mediated constitutional text that comes out of the constitutional conferences, right? National Party, the ANC, and they do a compromise on property rights, right? But it's certainly not constitutionalizing kind of a neoliberal version of property rights.
Yeah.
It's not that. So, and one last thing, because this is more of a comment than a question. New constitutionalism, which you refer to, which I've written about, really draws on the idea that Stephen Gill promoted, and that is that international institutions, international law, political negotiations are sort of constitutionalizing neoliberalism. He didn't have in mind actually domestic constitutions, though if pressed, he may have said yes. But he's thinking about the IMF and the World Bank principally as exhibiting features of the new constitutionalism. It's not the old, right, where nation states write down texts. This is outside or international or transnational constitution making that has that same bindingness, right, as domestic constitutional text. So that's the new constitutionalism literature.
That's a question about that, because I've seen that referred to also, like the work of Bruce Ackerman and Gardbaum and others but that's not what it is.
That's a different body of literature that refers to new constitutionalism. They have, and I've taken note of this, and they don't speak to each other, and they're coming out of two different, I think, scholarly traditions. And the one that I've been drawing on, the one that influenced Herschel, was international political economy. It was IPE. So I think that's all.
So with that, now the only thing that stands between all of us and a reception is ending the panel and thanking the panelists for their wonderful contributions. And thank you all for being here. And now we can turn to the last and final piece of the conference today, which is the reception, which I believe is upstairs.